in conclusion to my presentation, I would have four points that lead me to the fact that indeed judges do not make the law. Judges only declare the law, or judges unravel what the law is. And one of them is, one of the reasoning that I have is rules derive their meaning from principles. It is principles that informs the rules. It means if we don't have the principles, then judges would be making their decisions in a vacuum. But because we already have principles, judges have to follow the principles in arriving at their decision or in arriving at their judgment. So through the rules of precedent, judges only discover and declare the existing law and never make law. Secondly, a judge makes a decision not according to his own private judgment, but he makes a decision according to the law, to the known laws and customs of the land. It means a judge arrives at a decision by being informed by certain rules and principles, which are not delegated to pronounce a law. It is not the role, it is not the function of a judge to make law, but to inform what the law is or to unravel what the law is. The function of the courts, secondly, the function of the courts of justice is therefore not to make the law, but to ascertain and declare what the law is. Judges only discover the law, so the particular principle that governs individual cases arrive, or their decision arrived at information of the principles, information of those principles. It is also worth noting that when a judge interprets the law, he uses his ability, his creative function, to inject flesh and blood into the dry skeleton of the law. A matter is brought before a judge. When this matter is brought before him or before her, he has to inject fresh blood into the skeleton of that particular case. It means he needs to identify what is the weakness in that particular law, what is the lacuna in that law, and what needs to be done in order for that particular law to be changed. And it therefore leads us to the question, it therefore leads me to the conclusion that indeed judges do not make the law, but judges declare what the law is. They use principles, or their decisions are informed by principles, or they arrive at a decision on the basis of principles that they have, which come from interpretation of statutes. I'll now open up the forum for questions. I hand it back to you, Angela. Thank you.
Thank you so much, Counsel, for the perfect, excellent presentation. So there are two sides. So there's one school of thought that says that judges make the law. There's another school of thought that says judges declare the law, and you have stated your position. So I'll ask my question, then I'll allow Adam Mohammed to also ask his question. So Counsel, I have a question. And according to me, maybe there's no right or wrong answer. It just depends on the school of thought and how you are able to defend yourself. So I want to bring to your attention Justice Juma Chitembwe's judgment. So he acquitted. So he recently applied for the Chief Justice position, and he was interviewed. And there's a case that he did in 2017. I'll just read it. I'll just skim through it in the interest of time. So he acquitted 24-year-old Martin Charo in April 2016, and he argued that the offense of defilement should not be limited to age and penetration. And this is what he said: if those were to be taken as conclusive proof of defilement, then young girls who freely engage in sex and then opt to report to the police whenever they disagree with their boyfriends, it would be wrong. And that was his point of view. So he was, and then he stated, where the child behaves like an adult and willingly sneaks into men's houses for purposes of having sex, the court ought to treat such a child as a grown-up who knows what she is doing. So the appellant was 23 years old when the incident occurred. It would be unfair to have the appellant serve 20 years behind bars, yet the complainant was after sex from him. That is what the judge said. So I don't know what you think about that. So we're trying to link your presentation to what has happened in the courts before on whether, so in that aspect, did Justice Juma Chitembwe declare the law, or did he make the law? Or what are your thoughts? Go on. Thank you, Counsel.
Thank you. I think I can start by responding to that.
Most obliged.
So, yeah. So I would say that from the onset of the presentation, I said that as much as the court of law has a role in adjudicating matters, the courts and the judges also have a responsibility to grow the law. That is one. And two, apart from growing the law, they have to interpret the law as to lead into a positive result. That's a principal interpretation of the law. You interpret it in the sense that you inform the law, because if you look at the case of R versus R, a 1991 case that the initial court was actually relying on a 1736 ruling, but the House of Lords stated that as much as the law provides that a woman who has been married by a man automatically consents to sexual intercourse, times have changed. Interpretation of the law needs to conform to the social, economic aspects of the community. And looking at Justice Chitembwe's ruling, one would say we are living in an era of technology where people, or at our generation, actually maturity starts at a very tender age. A child is 10 years old, but knows a lot. They make certain decisions that you actually don't expect them to make. Should we then still rely on a law that will not lead us into a positive result? Or should we interpret the law as to grow it positively? That, in my view, might have been the reasoning behind that. Because you cannot look, and I agree with him, you cannot look at age and penetration. This particular person, this particular lady could be, or either of the parties could be at the minority age, meaning they've not attained 18 years of age, but they are at a position to declare or to give their consent. So if you say that by virtue of penetration, and this person is a minor, and therefore, in that instance, that particular person should be held culpable, in my view, it is discriminatory to the other party. Yes, that's my response.
Thank you, Counsel. Now we'll listen to Adam Muhammad. You can now speak. Just unmute and speak. Thank you.
Thank you so much, Chair. I first want to take this opportunity to thank Hassan for his presentation. His points were clearly and well articulated, although I have just a small question regarding judicial activism. So we've had cases of judicial activism where judges have been accused of legislating laws from the bench during court decisions, which are not informed by the law. They interpret the law in different ways. Basically, I'm not a lawyer, but I'm trying to put that across. So my question will be, is judicial activism a form of where judges are considered to be making laws at the bench, or is it just another way of interpreting the law?
Thank you, Adam Marjan. I would first begin by saying, that's a good question. I would start by saying, judiciary is an independent body. that has been created under our constitution. And therefore, in making its decision, it arrives at a decision on impartiality and at a position where it has been informed by principle. I would say, to a certain extent, and I've actually seen one of the presentations that sometimes back was made at the University of Nairobi by the former Chief Justice, Dr. William Mutunga, and it was around this issue of judicial activism. And for them, it was the interpretation, their interpretation, a good example would be Justice Odunga. Their interpretation of the law is to conform with the needs of the society. You cannot interpret, for example, I know judicial activism actually comes a lot, especially when the government loses most of their cases. So now they're saying the judiciary is taking advantage of its independence to, to curtail the function of the other arm of the government. But in the real sense, our constitution has created levels of appeal. If you're not satisfied by one position, you can actually go to the other level. And so judicial activism does not come in because the independence of the judiciary allows it to interpret the law. And I've also said, when judges are interpreting the law, they do not interpret the law in vacuum. They interpret the law on the existence of certain rules. And those rules have been informed by principles. It means when a judge arrives at a decision, he arrives at a decision on the basis of what does the law say? What does this principle outline? Suppose we interpret the law this, does it grow the law? So most of the time you realize that the interpretation grows the law. However, every person has a right to give their opinion with regard to what decision a judge has made, and you can always appeal to the next court level. But of course, it's still a debate that is there about judicial activism, where some people are saying that the judiciary has actually been captured by certain people. There was a certain period when you remember when the Supreme Court nullified the presidential election. There was this narrative about judicial activism, and that it seemed as if the other side of the political divide were the ones being favored by the judiciary, but it's a debate that is actually being there. Thank you. I hope I've responded to your question, Marjan.
Yes, Wakili, you have. Thank you so much.
Asante.
Thank you for the question. Anyone else with a question, an addition to the presentation that has just been made? You can feel free to raise your hand using, yes, I can see one hand. Mohammed Ibrahim, kindly unmute and ask your question. Thank you.
Thank you very much. First of all, I would like to state that it's a pleasure to be part of such an insightful presentation done by my brother Hussein Wakili. He's made it very clear that his stand on whether judges declare or make the law. He's saying that judges do declare the law or unravel what the law is, and they don't make the law. But being a student, I would want him to enlighten on, because I remember taking a class whereby, and I think he should be aware of this Albert Van Dicey, who was once in the UK, a great constitutional lawyer. And his stand was that majority of the laws actually are being made by judges, and he used to talk about judicial lawmaking. Or I would want him to just enlighten on what a judicial lawmaking or judicial legislation is, because looking at him, he said majority of the laws are actually codified by what the judges, the rulings that the judges have made, and hence later on are being referred upon. So I think I wouldn't want to prolong the question. I think my question has reached home. So I'll be waiting for the feedback from the Wakili. Thank you very much.
Thank you, Ibrahim. Thanks